So, Article 1380 provides us that contracts validly agreed upon may be rescinded in cases established by law. So, it just says here that there are specific contracts that can be rescinded. So, not all contracts can be rescinded. Contracts that can be rescinded will be further discussed in the next provision. Okay, so now, what is the meaning of rescission? Here, it is an equitable remedy granted by law to the contracting parties and sometimes even to third persons in order to secure reparation of damages caused them by a valid contract. So we should always remember that it should arise from a valid contract by means of restoration of things to their condition prior to the celebration of the said contracts. So we should always take note that when it comes to rescission, there is damages, injury, or lesion, and the restoration of things to their condition prior to the celebration of the contract. So when rescission happens, both parties will be restored as to their original positions before the contract even happens. Okay, so now let's discuss the difference of termination of contracts with rescission. So let's start first with termination. So prior to termination, the contract binds the parties and are obliged to observe its provisions. And the parties have to perform their obligations prior to their ejectment. And lastly, after termination, it does not restore the parties in their original situation. So to further explain termination of contracts, let's have a simple example. So for example, A employed B to build a house. A obliged himself to pay in a monthly basis. So let's say the contract that A and B entered into will last for 6 months. However, A terminated the contract in the 3rd month. So since A is paying B in a monthly basis, when the termination was in the 3rd month, B is not obliged to return the payment of A, since B already did his part of the obligation, and it's a termination of contract. Therefore, it does not restore the parties in their original situation. So it's like, let bygones be bygones, since it already happened, and it's that. And then termination just prevents the further performance of the obligation. So B will not anymore make the house for A. So for rescission, to rescind is to declare a contract void in its inception and to put an end to it as though it never were. So as if the contract was never made, and the parties are returned to their status quo ante. So unlike termination, it does not restore the parties in their original situation, whereas in rescission, the parties are returned to their status quo ante. So it's like they never made the contract. And then whatever they gave to the other party, it will be returned to them. So now let's look into the requisites of rescission. So actually, the requisites of rescission is just derived from its own meaning and from 1380. So here, first is the contract must be validly agreed upon, and second, there must be lesion or pecuniary prejudice or damage to one of the parties or to a third person, like we discussed a while ago, injury, lesion, or damages. Third is that the rescission must be based upon a case especially provided by law. So it's in 1380, which provides us that contracts validly agreed upon may be rescinded in cases established by law. So now let's look into. So fourth is, there must be no other legal remedy to obtain the reparation for the damage. So in short, it should be like your last resort to obtain the reparation for the damage. Fifth is, the party asking for rescission must be able to return what he is obliged to restore by the reason of contract. So the party who initiated the rescission of the contract should have what he is obliged to restore to the other party. So sixth is, The object of the contract must not be legally in the possession of a third person who did not act in bad faith. And seventh is the period for filing for action for rescission must not have prescribed, which is 4 years from the accrual of the right of action.
Good morning, everyone. I am Cesar Leo Bartolome. The previous speaker did a great job in the introduction of rescissible contracts. Rescissible contracts are those which have caused a particular economic damage, either to one of the parties or to a third person, and which may be set aside even if valid. It may be set aside in whole or in part depending on the extent of the damage caused. Now, I will discuss the types of rescissible contracts provided in Article 1381 of the Civil Code. The provision enumerated 5 various contracts that may be rescinded. Number 1, those which are entered into by guardians whenever the wards whom they represent suffer lesion by more than 1/4, that's 25% of the value of the things which are the object thereof. Second, those agreed upon in representation of absentees, if the latter suffer lesion stated in the preceding number. Third, those undertaken in fraud of creditors, when the latter cannot in any other manner collect the claims due to them. Fourth, those which refer to things under litigation, if they have been entered into by the defendant without the knowledge and approval of the litigants or of competent judicial authority. And fifth, all other contracts specially declared by law to be subject to rescission. To put into context, the rescissible contracts are the contracts entered into in behalf of wards, contracts agreed upon in representation of absentees, contracts undertaken in fraud of creditors, contracts which refer to things under litigation, also other instances as provided by or in Article 1098, Article 1470, 1659, 1539, and 1599 of the Civil Code, and also contracts in violation of right of first refusal. In the first 4 cases, which are contracts entered into in behalf of wards, there's contracts agreed upon in representation of absentees, contracts which refer to things under litigation, also contracts undertaken in fraud of creditors. These are contracts entered into by persons exercising in fiduciary capacity, meaning persons who holds a legal relationship of trust with one or more parties. The first case of rescissible contract are those contracts entered into in behalf of wards. Now, who are wards? Now, a ward is a person under guardianship by reason of some incapacity, as provided in Article 1329. This means that the court appointed a guardian for a person by reason of incapacity, and the guardian entered into a contract. Now, the guardian entered into a contract where the ward, being the owner of the property, subject or the object of that contract, suffers damage of more than 25% of the value of the property, then the contract is rescissible. Except with court approval, which is going to be discussed in Article 1386. An example case is Gina is the guardian of Wally. the ward. Gina sells the property of Wally worth 20,000 pesos for only 15,000. The question is the contract rescissible? No. The contract of sale cannot be rescinded because the lesión is not more than 1/4 or 25%. However, if the property is sold for less than 15,000, then Wally can rescind the sale or that particular sale by proper action in court upon reaching the age of majority. Now, the next rescissible contract are those contracts entered or agreed upon in representation of absentees. An absentee is a person who disappears from his domicile, his whereabouts being unknown, and without leaving an agent to administer his property. The absentee must suffer lesion by more than 25% of the value of the property object of the contract to entitle him to the remedy of rescission. Now, if you noticed, the first and second cases of rescissible contracts refer only to transactions by guardians and absentees' representatives. Rescission cannot take place if the contracts have been approved by the court. As a general rule, lesion does not invalidate a contract except only in special cases as specified in Article 1355, like fraud, mistake, and undue influence. The next case of rescissible contract are those contracts undertaken in fraud of creditors. This is called acción poliana, or the action to rescind in fraud of creditors. There are requisites of acción poliana. 1. There must be a credit existing prior to the celebration of the contract. Also, there must be a fraud, or at least the intent to commit fraud to the prejudice of the creditor seeking rescission. The creditor cannot in any legal manner collect his credit, and the object of the contract must not be legally in possession of a third person who is in good faith. The purpose of this remedy is to secure the payment of an existing credit of a third person against a party to a contract sought to be rescinded. Now, all these circumstances must concur in a given case. The presence of one of them is not enough. In order that a contract of sale may be rescinded as in fraud of creditors, it is necessary that it be shown that both contracting parties acted maliciously and with fraud, and that for the purpose of prejudicing the creditor. Unfortunately, rescission is generally unavailing should a third person acting in good faith is in lawful possession of the property. That is to say, he is protected by a law against a suit for rescission. Therefore, contracts entered into without such mal intent are not rescissible, even if, as a consequence thereof, the creditor may suffer some damage. Now, the burden of providing by competent evidence the existence of such fraudulent intent on the part of the creditor or the debtor rests on the creditor who is seeking rescission. We go to contracts, which refer to things under litigation. These are contracts entered into without the knowledge or approval of litigants or even the court. Now, an example case is Sam sues Vic for the recovery of a parcel of land. In this case, the land is under litigation. During the pendency of the case, Vic sells the land to Tima without the approval of Sam or the court. The sale is rescissible at the instance of Sam in case he wins in his suit for the recovery of the said land, unless Tima is in legal possession of the land in good faith. Sam, however, may protect his right by filing a notice of lis pendens. Now, the purpose of lis pendens is to give notice to the world, to the whole world. On the other hand, if personal property is involved, the property may be levied by writ of preliminary attachment. The next rescissible contract is in violation of right of first refusal. The Supreme Court, in number of cases, upheld the rescission of a deed of sale which violated a right of first refusal, granted to one of the parties, in which case the lessee. The prevailing doctrine is that a right of first refusal means identity of terms and conditions to be offered to the lessee and all other prospective buyers, and a contract of sale entered into in violation of the right is rescissible. Now, such violation constitutes a valid cause of action enforceable by an action for specific performance. Where there is no showing of bad faith in the part of the vendee, the sale may not be rescinded. But the remedy of the person with the right of first refusal is an action for damages against the vendor. It is also important for us to distinguish the distinction between rescission for breach of contract, that's under Article 1991, and a rescission by reason of lesion or economic prejudice under Article 1381. Now, the rescission is a principal action, retaliatory in character, and it being unjust that a party be held bound to fulfill his promises when the other violates his, and therefore the reparation of damages for the breach is purely secondary. On the other hand, in the rescission by reason of lesion or economic prejudice, the cause of action is subordinate to the existence of that prejudice because it is raison d'etre or justification for existence, as well as the measure of the right to rescind. But the operation of these two articles is limited to the cases to rescission or cases of rescission for lesion enumerated in Article 1381, and it does not apply to cases under Article 1191. And lastly, rescissible contracts also include Article 1098, that's under succession, Articles 1470, 1539, 1599 under sales, and Article 1659, that's lease, which will be discussed accordingly. The next speaker will discuss Article 1382. Thank you for watching.
Article 1382. Payments made in a state of insolvency for obligations to whose fulfillment the debtor could not be compelled at the time they were effected are also rescissible. A debtor is considered insolvent if he has no sufficient properties to meet his obligations. But for this article to be applicable, it is not required that insolvency should be judicially declared. In addition, Article 1382 speaks of payments and not exactly of a contract, so it is not included under Article 1381. There are two essential requisites under this article. First, that the debtor must have been insolvent, and second, that the obligation was not yet due and demandable. Those obligations which are not legally demandable, such as natural obligations, and those that have prescribed, are included under the second requisite. Example of Article 1382. A is indebted to B and C for 10,000 and 5,000 respectively. A was insolvent, and although the debt was not yet due and demandable, he made payment to B. At the same time, A made also a payment to C for an obligation which is already due and demandable. Are the payments made by A to B and C rescissible? The payment made by A to B is rescissible because it was made in a state of insolvency for an obligation to whose fulfillment A could not be compelled at the time it was effected. However, the payment made by A to C is not rescissible because even though A was insolvent, the debt was already due and demandable.
Hi, I'm Robert De Liera, and I'm going to report Article 1383, which provides that the action for rescission is subsidiary. It cannot be instituted except when the party suffering damage has no other legal means to obtain reparation for the same. Before going further, we should first know that the rescission of contracts under Article 1383 is distinguished from rescission of reciprocal obligations under Article 1191. What are these distinctions? First, as to nature, rescission in Article 1191, it is a principal action which is retaliatory in character, while rescission in Article 1383, it is a subsidiary remedy only. Second, what are the grounds for rescission? Under Article 1191, the only ground is non-performance of the obligation that is incumbent upon him. While in Article 1383, its its grounds for rescission are those enumerated in Article 1381, which was previously discussed by my colleague. Also, we should note that non-performance is not important in this article. Third, who may institute the action? Under Article 1191, only a party to the contract may demand fulfillment or seek rescission of the contract. While in Article 1383, even a third person who is prejudiced by the contract may demand the rescission of the contract. Fourth, its applicability. A rescission in Article 1191 only applies to reciprocal obligations, while rescission in Article 1383 applies to both unilateral and reciprocal obligations. Fifth, finally, purpose. The purpose for rescission in Article 1191, its purpose is to cancel the contract, while in Article 1383, its purpose is to seek reparation for the damage or injury caused. Now, what are the nature of action for rescission? First, it's a subsidiary remedy. It means it can only be availed if the injured party proves that he has no other legal means, aside from rescinding the contract, to obtain satisfaction for his claim or redress for the damage caused. The rule obtains even if the contract is covered by Article 1381. You should also note that the right to rescissory action is in line with Article 1177, which provides the creditors, after having pursued the property in possession of the debtor to satisfy their claims, may exercise all the rights and bring all the actions of the latter for the same purpose, save those which are inherent in his person. They may also impugn the acts which the debtor may have done to defraud them. What are these legal means that the creditor may institute before asking for the rescission of the contract? Here are the following means that the creditor may do or may avail. First is to exhaust the properties of the debtor through levying by attachment and execution upon the property of the debtor, except such as exempt by law from execution. Second, exercise all the rights and actions of the debtor, save those personal to him. And finally, seek rescission of the contracts executed by the debtor in fraud of their rights. We should also note that it is an independent action. It means that a rescissible contract may assay directly only by a proper action in court and not indirectly or collaterally by way of defense. An independent action is necessary to prove that a contract is rescissible. We should also note who are the persons allowed to institute the action. First and foremost, the creditor. Second, the parties who suffered economic lesion. And finally, others authorized by law in case of death or incapacity. However, we should also note that there is an exception to the rule. If it can be proven that the property alienated was the only property of the debtor at the time, at the time of the transaction, the action for rescission is certainly maintainable because it is clear that the creditor has no other legal remedies under the circumstances. Uh, Thank you. That ends my report. On to Article 1384.
Good day, I'm Joseph Nathaniel Gonzalez and I'm gonna be discussing Article 1384 of the new Civil Code, which covers the extent of rescission. Article 1384 provides that rescission shall be only to the extent necessary to cover the damages caused. This provision is actually self-explanatory, but to discuss it, let us go back to the concept of rescission as contemplated in Article 1380 of the new Civil Code. As we have learned from the first reporter, rescission is a remedy granted by the law to the contracting parties and even to third person to secure the reparation of damages caused to them by a contract, even if the same should be valid by means of restoration of the things to their condition prior to the celebration of the contract. Based on this concept, it must be observed that the rationale behind this provision is because the purpose of rescission is to repair the damage or the injury which is suffered either by the party to the contract or by a third person, and in order that this purpose may be realized, the rescission doesn't necessarily to be total in character, but it may also be partial. For example, A and B entered into a lease contract. B is the lessor and A is the lessee. As part of the contract, B is prohibited to paint the walls of the apartment. B violated the contract and therefore A seeks rescission. Assuming that the above contract is really rescissible, the extent of the damage that can be covered is only the damage caused by painting the walls of the apartment and nothing more. Because according to Article 1384, rescission shall be only to the extent necessary to cover the damages caused. Now let's proceed to the case of HSBC versus Pauli. Here are the facts of this case. On June 14, 1957, the Hong Kong and Shanghai Banking Corporation filed a complaint against the defendant Ralph Pauli to collect the sum of 258,964 pesos and 15 centavos. After the trial, judgment was rendered in favor of the bank on June 2, 1959, ordering defendant to pay the plaintiff the sum of 219,236 pesos and 20 centavos with legal interest thereon from June 14, 1957 until fully paid and the cost. The decision having become final, the bank endeavored to execute it, but the writs of execution were returned unsatisfied because no leviable assets of Pauli could be located by the sheriffs. Unknown to the Hong Kong and Shanghai Bank, Pauli had on January 8, 1957 purchased from the Philippine National Bank a sugarcane plantation known as Hacienda Riverside. To avoid discovery of the transaction by his creditors, he did not register the deed of sale. 6 years later, on March 1, 1963, he fraudulently sold the hacienda to his daughter, defendant appellee Sally Garganera, and her husband Mateo Garganera. The sale was registered on March 5, 1963. Transfer certificate of title number 34425 was issued to the Garganeras. In another civil case filed by Warner Barnes and Corporation, another creditor of Pauli, the sale to spouses Garganera was declared fictitious for being in fraud of creditors. Having discovered that the hacienda belonged to Pauli, HSBC filed a complaint for revival of previous judgment on January 13, 1969, wherein the court ordered Pauli to pay HSBC. HSBC filed another civil case to annul the consolidated sale as well as the deed of sale of the disputed hacienda. Pauli argues that the case is barred by prescription. HSBC counters that the 4-year period commenced to run from the date when they had actual knowledge of the fraudulent sale. Hence, the action has not yet prescribed. The issue in this case is whether or not the action for annulment of the sale of the hacienda to Garganeras prescribed, and the court says yes, the action has prescribed. HSBC's theory would diminish public faith in the integrity of Torrens titles and impair commercial transactions involving registered lands, for it would render uncertain the computation of the period for the prescription of such actions. When a transaction involves registered land, the 4-year period fixed in Article 1391, within which to bring an action for annulment of the deed, shall be computed from the registration of the conveyance, which is March 5, 1963, on the familiar theory that the registration of the document is constructive notice of the conveyance to the whole world.
Greetings of peace and goodwill. I am Ibli Bernadette Allen Activa, and I will be your reporter for today. My topic is all about rescissible contracts. Under Article 1385 of the Civil Code, rescission creates the obligation to return the things which were the object of the contract, together with their fruits, and the price with its interest. Consequently, it can be carried out only when he who demands can return whatever he may be obliged to restore. Neither shall rescission take place when the things which are the object of the contract are legally in possession of third persons who did not act in bad faith. In this case, indemnity for damages may be demanded from the person causing the loss. So, Article 1385 refers to contracts that are rescissible under Articles 1381 and Article 1382. But it does not refer to contracts that are dissolved by mutual consent of the parties. Rather, the mutual restoration is in consonance with the basic principle that when an obligation is dissolved or extinguished, it is the duty of the court to require the parties to return whatever they may have received from the other, so they may be restored as far as practicable in the original situation. The effects of rescission creates the obligation of mutual restitution. There is no obligation to restore if nothing has been received. when the court declares a contract rescinded, the parties must return to each other first uh, the object of the contract with their fruits, and second, the price thereof with legal interest. So, for example, when a contract of sale has been rescinded by the buyer, the seller has the obligation to return the purchase price or the amount received with plus legal interest from the date he received notice of the rescission up to the date of return. So, the word fruits, as used in Article 1385, should deem that to include not only the natural, civil, and industrial fruits, but also its accessions and the accessories of the things to be returned. When it is no longer possible to return the object of the contract, an indemnity for damages operates as a restitution. The important consideration is that the indemnity for damages should restore when when rescission is granted, it has all the effects of abrogating the contract in all respects. The party seeking rescission cannot ask performance as to part and rescission as to remainder, except as provided in Article 1384. So, next effect is the obligation to third persons to restore. To restore. If the third person has nothing to restore, the article does not apply. The law does not require for the impossible. Thus, when a contract of when a contract is rescinded on the ground that it has been entered into in fraud of creditors, the plaintiff creditor cannot has no obligation um, to return anything because he has nothing, he has received nothing. So that's it for the effects. There are three effects. Again, the obligation of mutual restitution. Second, abrogation of contract. Third, obligation of third persons to restore. So now we go to when rescission is not allowed. Rescission is not allowed first if the party who demands rescission cannot return what he is obliged to restore under the contract. Second, if if the property is legally in possession of third persons who acted in good faith. That is to say, the third person has acquired the property and registered it to the registry of property and unaware of the flaw of the title and the mode of acquisition. So that's it for Article 1385. And thank you.
Good morning, good afternoon, or good evening as to what time this video may be viewed. Now, the topic of our group is rescissible contracts. Before we go along to the provision that was assigned to me to report, Let us go back to the definition of rescissible contracts. Rescissible contracts are contracts which are valid but defective because of injury or damage to either of the contracting parties or even to a third person, and as a consequence thereof, it may be rescinded by the means of a proper action for rescission. Now, let us define what is rescission is. Now, rescission again is a remedy granted and or provided by the law to the contracting parties and even to a third person to secure the reparation of damages. Now, in this provision, Article 1386 states that rescission referred to in numbers 1 and 2 of Article 1381 shall not take place with respect to contracts approved by court. Now, let us go back what is numbers 1 and 2 of Article 1381. Now, it simply states that paragraph 1, those which entered into by guardians whenever the wards whom they represent suffer lesion by more than one-fourth of the value of the things which are object thereof. Paragraph 2 states that those agreed upon in representation of absentees if the latter suffer the lesion stated in the preceding number. Now, guardians, as a general rule, can enter into contracts that involves acts of administration without court approval. It can be rescinded if there's a lesion suffered. Now, here in Article 1386, it simply states that if a contract entered into a behalf of a ward or absentee that has been approved by the court, rescission cannot take place because it is valid whether there is a lesion or not. The law presumes that the court is acting in the interest of the ward or absentee when it approves the contract in spite of lesion. Now here in this provision, it simply states that even if there's a lesion or damage on the contract that have been entered by the administrator or the guardian, even if there's a lesion, it cannot be rescinded because it is already approved by the court. So, thank you very much. That ends my report.
Hello, good morning, good afternoon, good evening. I am Renalyn G. Pignon and I will be reporting Article 1387. Under Article 1387, it states that all contracts by virtue of which the debtor alienates property by gratuitous title are presumed to have been entered into in fraud of creditors when the donor did not reserve sufficient property to pay all debts contracted before the donation. Alienations by onerous title are also presumed fraudulent when made by persons against whom some judgment has been issued. The decision or attachment need not refer to the property alienated and need not have been obtained by the party seeking the rescission. In addition to these presumptions, the design to defraud creditors may be proved in any other manner recognized by the law of evidence. Instances in Article 1387 are not exclusive of others and may be proved in any manner recognized by the law of evidence. Presumption not applicable in the absence of transfer, meaning this article is only applicable when there is a fact of alienation or transfer, whether gratuitously or through onerous title. Only actual creditors can ask for rescission. Only actual creditors can ask for rescission of conveyance made by their debtors in favor of strangers. Vendor, an indispensable party in action for rescission of sale. An action for rescission of sale under Article 1387 cannot be finally determined without the presence in court of the vendor, since the decision on the action or claim for damage would affect and therefore he is entitled to be heard. Article 1387, Presumptions of Fraud. Again, under this article, the presumptions of fraud are made by the debtor. On the gratuitous alienations presumed fraudulent when the debtor did not reserve sufficient property to pay all debts contracted before the donation. On the other hand, the onerous alienations presumed to be fraudulent when made by persons against whom some judgment has been rendered in any instance, thus, even if not yet a final judgment, or against whom some writ of attachment has been issued. For the onerous alienations, we have an example. After a judgment had been rendered against B, B sold his property to C. Is the sale presumed fraudulent? Yes. The sale here is presumed fraudulent because it was made after a judgment has been made against B. On the other hand, if the sale had been made before the judgment, the presumption of fraud cannot be applied. This is so even if it is unknown to the buyer that the suit has been filed or already been brought, but still pending as long as, of course, no attachment had been issued. Under Article 1387, there are also badges of fraud or circumstances evidencing fraud. However, these circumstances are not absolute or exclusive, since the court has the liberty to interpret or to deal with fraud depending on how fraud was presented on a case may be. So, badges of fraud. 1. The fact that the consideration of the conveyance is fictitious or inadequate. A transfer made by a debtor after suit has been begun and while it is pending against him. 3. A sale upon credit by an insolvent debtor. 4. The transfer of all or nearly all of his property by a debtor, especially when he is insolvent or greatly embarrassed financially. 5th, evidence of large indebtedness or complete insolvency. 6. The fact that the transfer is made between father and son, when this fact is considered together with preceding circumstances. 7. The failure of the vendee to take exclusive possession of all the property. Article 1387. Rule in case of registered lands. Presumptions of fraud under Article 1387 are not applicable to registered lands under torrent system if the judgment or attachment made is not also registered. Valid before rescission. For this, we have an example. To defraud his creditors, D sold his real property to E before rescission. Is the sale valid? Yes, it is valid until they are rescinded, they are legally effective, and can convey title. Necessity of a direct action for rescission. Before rescission, the sale is valid and cannot be attacked collaterally. Presumption of validity. A gratuitous conveyance or donation validly executed on its face, presumed valid and good as between the parties. It cannot be declared fraudulent and therefore subject to rescission unless it can be shown that at the time of the execution of the conveyance, there was a creditor or creditors whom said transaction may affect adversely. Fraud alone not sufficient for rescission. Even if the debtor who made the alienation acted fraudulently, if the transferee acted in good faith and with valuable consideration, rescission will not be allowed. So that's it for Article 1387, and thank you for watching.
Continue the discussion on rescissible contract. Allow me to read and discuss Article 1388. I am Eric Recomendable and I am part of Group 1. Article 1388. Whoever acquires in bad faith the things alienated in fraud of creditors shall indemnify the latter for damages suffered by them on account of the alienation, whenever, due to any cause, it should be impossible for him to return them. If there are two or more alienations, the first acquirer shall be liable first, and so on successively. Basically, Article 1388 speaks of the remedy of the creditor from its debtor and to the third person. Remember, in Article 1385, second paragraph, it provides that the contract cannot be rescinded if it acquires in good faith. So the third person or party is absolved of any liability if he or she is in good faith. What if he acquires it in bad faith? The effect of bad faith. The acquirer or purchaser must return or indemnify. So the purchaser must return that things or object if he is able to return it, or indemnify if the object of the things are impossible to return. Letter B. Due to any cause which includes a fortuitous event. If the object or the things are destroyed by any cause, the third person must indemnify the creditor. Example, to defraud his creditors, A sold his house to B, who knew of A's purpose. If the sale is rescinded, B must indemnify even if the house be destroyed by a fortuitous event, but only if A himself cannot pay. Remember, in Article 1383, the action for rescission is merely a secondary remedy available only when A cannot pay. Subsequent transfer. If the first transferee is in good faith, the good or bad faith of the next transferee is not important. As I have mentioned earlier, Article 1385 absolves the person who acquires the object in good faith. So being the rightful owner of the object or the thing, the succeeding alienation will no longer matter the good or bad faith of the acquirer. Letter B. If the first transferee is in bad faith, the next transferee is liable only if he is also in bad faith. Example, A, in front of creditors, sold his house to B, who is in bad faith. B, in turn, alienated it in favor of C, who later sold it to D. Both C and D were also in bad faith. The contract is rescinded, but the house is destroyed. Who, if any, are liable for damages? B will be the first liable. If he cannot pay, then C will be liable. If C can also pay, D will be liable. Additional, bad faith has been defined as a state of mind affirmatively operating with furtive design or with some motive or self-interest or ill will or for an ulterior purpose, and implies a conscious and intentional design to do a wrongful act for dishonest purpose or moral obliquity. Republic versus Deserto and Gatmaitan versus Gonzales. Thank you.
Good day, attorney and classmates. I am Ruby Ruth Ray Boneria, tasked to discuss and report the seventh requisite of rescission, which is covered by Article 1389. So, let's start. Article 1389 provides that the action to claim rescission must be commenced within 4 years. For persons under guardianship and for absentees, the period of 4 years shall not begin until the termination of the former's incapacity or until the domicile of the latter is known. So essentially, it talks about the prescriptive period in filing an action to claim rescission. But before we go through that and further understand the prescription or the prescriptive period, let us first understand when does an action to rescind or an action Pauliana accrue. So of course, it has 5 essential requisites. What are these requisites? So letter A, that the plaintiff asking for rescission has a credit prior to the alienation, although demandable later. B, that the debtor has made a subsequent contract conveying a patrimonial benefit to a third person. C, that the creditor has no other legal remedy to satisfy his claim but would benefit by rescission of the conveyance to the third person. Letter D, that the act being impugned is fraudulent. And lastly, that the third person who received the property conveyed, if by onerous title, has been an accomplice in the fraud. So next, for an action Pollyanna to accrue, it should be an action of last resort. So it means it only accrues when the creditor discovers that he has no other legal remedy for the satisfaction of his claim against the debtor, meaning for as long as the creditor still has a remedy at law for the enforcement of his claim against the debtor for rescission of the contracts entered into by and between the debtor and another person. So third, for an action Pauliana to accrue, the debtor's property should be exhausted. It means it presupposes a judgment and the issuance by the trial court of a writ of execution for the satisfaction of the judgment and the failure of the sheriff to enforce and satisfy the judgment of the court. Lastly, for an action Pollyanna to accrue, we should also consider it priority in time of credit. So, in reference to the case Cheng versus Court of Appeals, we should note that the date of the decision of the trial court against the debtor is immaterial. What is important is that the credit of the plaintiff antedates that of the fraudulent alienation by the debtor of his property. After all, the decision of the trial court against the debtor will retroact to the time when the debtor became indebted to the creditor. Now, let's go to the important part of this provision. When do we institute an action for rescission? Article 1389 tells us that it should commence within 4 years, but it's actually silent as to when the 4 years period should start, although it gave us 2 circumstances for this. Under the second paragraph, it tells us that for persons under guardianship, it must be from the time of the termination of his incapacity, while for absentees or a person who disappears from his domicile and whereabouts becomes unknown, it shall commence upon knowing his domicile. Now, suppose it does not fall under these 2. When shall we start the 4-year period? Article 1389 is silent again about that. Hence, the Supreme Court took the opportunity in its decision in the case of Ke Hong Cheng versus Court of Appeals to give us the general rule in this case, which says it should commence from the moment the cause of action accrues, or under Article 1150, from the day the action may be brought. However, note that counting will differ under other circumstances. Say, where the action for rescission is based on fraud, the period must be counted from the time of the celebration of the contract. And in cases where the fulfillment of the obligation of the seller became impossible because of a judgment rendered against the seller, as held in Aison Simon versus Adamos, the action for rescission must be commenced within, again, 4 years, just like the others, but from the date of judgment when it becomes final and executory as per entry of the judgment. Again, it will be based on the finality of the judgment. So, okay. Now that we now understand the prescriptive period in the commencement of the prescriptive period, we now go to the last topic, but still is essential, of course. The persons entitled to bring the action for rescission and their rights. So we have three for this. First, we have the injured part or the defrauded creditor, which while his right against the seller debtor is only a personal right to receive payment for the loan, it is not a real right over the property subject of the sale. Meaning, while he has an interest in securing payment of the loan, such right does not in any manner attach to a particular portion of the patrimony of the debtor. Hence, he must first avail of the remedies, again provided in Article 117 of the Civil Code or of the new Civil Code, before he can file an action for rescission. Again, to reiterate, an action for rescission is always an action of last resort. Thus this thus this stipulation. So second, the heirs, assigns, or successors in interest. Their rights are actually similar to a credit of a creditor insofar as the right to the legitime may be defeated by fraudulent contracts. Thus, the compulsory heirs instituted as such by their father in the latter's testament have the undeniable right to institute an action to rescind contracts entered into by the father to their prejudice. And lastly, the creditors of one of the previous two, or the injured party or the defrauded creditor, and the heirs, assigns, or successors in interest entitled to subrogation or action subrogatoria as discussed under Article 117 of the new Civil Code. So that's it. Thank you, and please keep safe.
Good day, sir. I'm Zachary Shanko, tasked to report about the case of Caballero versus Sadora. In the case of Caballero versus Sadora, Isidora Caballero is the second wife of Benigno Sadora. They had a daughter named Soledad Sadora. During their marriage, they acquired 2 parcels of land located in Nueva Vizcaya. Having been abandoned by her husband, Isidora Caballero instituted an action for support with the Court of First Instance of Manila. On January 30, 1933, judgment was rendered requiring Benigno Sadora to pay his wife the amount of 75 pesos a month in terms of support as of January 1, 1933, and 150 pesos in concept of attorney's fees and the cost. But Benigno failed to comply with the judgment of the court. Isidora filed a motion to cite Benigno Sadora for contempt, and the Court of First Instance of Manila authorized Isidora to take possession of the conjugal property, to administer the same, and to avail herself of the fruits thereof in payment of the monthly support in arrears. With the order of the court, Isidora proceeded to Nueva Vizcaya to take possession of the aforementioned parcels of land. And it was then that she discovered that her husband had sold them to his son-in-law, Sotero. On February 1, 1940, Isidora filed with the Court of First Instance of Nueva Vizcaya against her husband and Sotero Sadora for the recovery of the lands in question on the ground that the sale was fictitious. At the same time, a notice of lease pendants was filed with the Register of Deeds of Nueva Vizcaya. However, in May of 1940, Benigno Sadora died. After trial, the lower court rendered judgment and, among other things, declared the deeds of sale executed by Benigno Sadora to be simulated and fictitious, recognized and upheld the rights of the intervenor purchasers, who acquired their portions prior to the registration of the Notice of Lease Pendants on October 1, 1954, but dismissed the claims of the intervenors who allegedly bought parts of the land subsequent thereto, and ordered the partition of the remaining unsold lands between Isidora Caballero, Sotero Sadora on one hand, and the children by the first marriage of Benigno Sadora on the other. Sotero appealed to the Court of Appeals, and the court reversed the decision of the trial court with regard to the 2 parcels of land and dismissed the amended complaint of Isidora Caballero. Hence, Isidora Caballero brought the case to the Supreme Court. The issue in this case is whether or not there is a presumption of fraud against Sotero Sadora. And the court held that yes, there is a presumption of fraud. Article 1387 of the Civil Code of the Philippines states that alienation by onerous title are also presumed fraudulent when made by persons against whom some judgment has been rendered in any instance or some writ of attachment has been issued. The decision or attachment need not refer to the property alienated and need not have been obtained by the party seeking the rescission. The presumption of fraud was established at the time of conveyance. The fact that Sotero was living with his father-in-law and he knew that there was a judgment directing the latter to give a monthly support to his wife Isidora, and that his father-in-law was avoiding payment and execution of the judgment. It was known to Sotero that his father-in-law had no properties other than those 2 parcels of land which were being sold to him. The fact that the vendor transfers all of his properties to a third person when there is judgment against him is a strong indication of a scheme to defraud one who may have valid interest over his properties. The close relationship between Benigno and Sotero is called to be a badge of fraud. The decision of the trial court stands affirmed with cause against the private respondents.